Hello, my name is Andrew Feldstein, and thank you for joining us here on the Ask Andrew show. It's the first and only question and answer Facebook Live family law show. And today we have a guest who is a well known criminal lawyer that appears on radio and TV all the time, Ed Prutschi. I wanted to thank you for joining me today.
Thanks very much for having me, Andrew. I'm looking forward to it.
Now, Ed, I always find as a family law lawyer, there's plenty of intersection that goes on between family law and criminal law. And one of the things that I want to discuss with you is how often do you deal with domestic assault cases? Because that's really what family law seems to interact with criminal law the most.
Yeah, absolutely. I mean, the short answer is almost every single day. The reality is that if you're a busy criminal law practitioner, as I am and as our firm is, you'll deal with a lot of different lawyers. You've got the personal injury lawyers, you've got the employment lawyers, you certainly have intersection with immigration, but by far, and by a wide margin, the number one most common overlap is with family law, and it's almost always in the domestic violence context. So it's your classic domestic assault allegation, one party on another. And we actually will represent both sides, obviously not at the same time, but we get people who have made the allegations and they want a criminal lawyer to help them walk them through that process, understand what the Crown Attorney is going to expect of them. Sometimes it's because they want to back off of an allegation that they've made, and the process entangles them. I'm sure we'll get a chance to talk about that further, so much so that they can't back off of what they said earlier. But the most common one is a person who comes forward and says, look, I'm in the middle of a really bitter divorce. An allegation was made. It's completely fabricated, but I got to deal with this. And my family lawyer says I should talk to you.
Now, I know in my experience, one of the frustrating things is clients come into my office and they'll frequently say, I want my spouse to leave the house, or my spouse wants me to leave the house. And I explain to them that in family law, there's something called exclusive possession, and you can go to court and get that order. But the order is A, typically very difficult to get, and B, can take many months to get. And I know people sometimes talk to one another, and sometimes what you hear is a discussion of they learn that if there are criminal charges laid, most likely they're not going to be allowed to be in the home. And we get into when it's our clients who were the ones that were arrested say, I never did anything. And how often do you see that kind of fact pattern happening?
That's extremely common. I never find out what the impetus was for that, whether that's because someone just heard it from a friend, they Googled it somewhere, or whether an unscrupulous family lawyer, not somebody from the Feldstein group, has said, what would really make your case move forward a lot quicker or put some pressure on the other side is fabricating an allegation like this. So I never know how it commences, but I see it very early on in the process where someone comes in and says, things were going reasonably well. Then out of the blue, there was a motion or a backtrack. Something was happening in family court. And lo and behold, the day or even just the weeks before, it looked like we were going to be able to resolve this, or a custody issue came up. Next thing you know, I'm finding out about an allegation, sometimes even a historical allegation, but the cops are at my door. I get arrested. And even if I don't spend much time in jail or any time in jail, inevitably, the very next thing that happens is I have to sign conditions that say I can no longer go back to the home. I can no longer communicate with my spouse. I can no longer have free access to my children. And of course, the panic sets in because there's a family court motion coming just days or weeks away where all of these issues are central.
Now, what I find interesting in that type of scenario is what you can do to prevent it. Because I frequently will sit down with my clients and they say to me at the beginning, do I have to leave the house? My spouse wants me to leave, or the alternative, I want my spouse to leave. And I say, you don't have to leave. But I warn them that if you think that your spouse is going to call the police on you and that there may be some staying power to what the allegations are, you may want to voluntarily leave and negotiate a schedule, because who wants to pay two lawyers, who wants to be arrested, and who wants to deal with that?
Yeah, look, there's no doubt that if you are legitimately fearing that there's a criminal charge coming, and that discretion being the better part of valor, stepping out of the home and working something out after the fact is going to prevent that charge from coming, you'll be far, far better off having done it that way. Now, I won't be, because I'll miss out the wonderful opportunity to have spent months and months and months and thousands of your dollars to deal with that, but certainly you'll come out ahead. So what I tell people is that obviously they need to communicate with their family lawyers to get a sense of what are they giving up if they decide to step away from the home. But if there's a real fear and a real benefit that says if you move away, you're going to avoid getting into criminal court, that's something they ought to give real consideration to. The other thing I talk to clients about all the time is how to protect themselves if it is inevitably heading to criminal court. And oftentimes it's too late by the time a client comes into my office to retroactively make those changes. But when I educate family lawyers and speak to other family lawyers about it and say, look, now's the time to be advising your client, watch out for these things, have a witness around, maintain records like social media accounts, like emails, like video if there is. A lot of homes now are wired, and so there's videotape of when you come in and when you go out. People are taping everything on their phone so that when there's an allegation that says he hit me or we had this argument or he stole this amount of money or she did X or Y, you're able to go back to primary documents and say, wait a second, that doesn't sound right. I was on a business trip at this time, or I've got this video of how the argument actually started, or I can show you the social media accounts after the fact where my spouse is sort of gleefully boasting about the trick they managed to pull off.
Now, it's interesting you say that, because I've had this situation before where clients will say, my criminal lawyer told me I should record everything or videotape everything. But as a family law lawyer, we tell them you shouldn't be doing that because a family court is going to frown upon it. Because what they don't like seeing is the person who walks around their home with their phone out, I'm videotaping you, and the kids are seeing it in the background, or when there's an exchange and they're saying they're videotaping. And I say that because there's a conflict that goes on and a tension between what may be good for a criminal law case and what may be good for a family law case. And I think what you have to balance in that scenario is, if you are going to record the transaction, what I've said to some of my clients, when they're still in the home and the other person is coming to the exchange, don't use your phone to videotape it. Go put in a camera at the front door. It's not as toxic and in your face and as offensive, and try to find things like that. And the other thing where we get to the conflict between family and criminal laws, and family law, there's no doubt you're hurting your case when you move out voluntarily in terms of a parenting schedule. You are, but you're not hurting your case as much in a family law context as if you were arrested. So it's a matter of balancing the lesser of two evils.
And so it's really interesting because that conflict is something that makes it so much more important that lawyers, family lawyers and criminal lawyers, have a very open lane of communication. So inevitably, when I get retained by somebody who comes through a family lawyer, my first question is, who's doing your family law work? I want their phone number, their cell phone number. I want access to that person, unfortunately, 24/7, because questions are going to arise where we want to get answers right away. And I don't want to do anything on the criminal side that's going to negatively impact the family side, at least not without having had that discussion with the family lawyer so that we know the pros and cons. And as you indicated, stepping out of the home, it's going to have a negative impact on your family proceedings potentially, but maybe it's the lesser of two evils. So make sure your professionals are communicating and can make that educated decision.
Well, I couldn't agree more, because one of the things that concerns me, and I've seen family law lawyers make this mistake, is there are criminal charges and there's allegations in the family court application by their spouse dealing with those allegations of abuse. And as a family law lawyer, you want to give an answer, but that answer may not be a good answer for the criminal case. And I try to make sure that when we're putting in our response, which is called an answer, that the criminal lawyer has an opportunity to review it, edit it, and make their comments. Because what I don't ever want to hear one of my clients saying is, I was cross-examined at my criminal trial and lost because of something you put in court material, Andrew.
And that's a perfect example. I get that all the time with family court proceedings where people make all sorts of outrageous claims in their pleadings. And then in the family court, they may respond, and they do that without even having waited to get the criminal law disclosure. So they're doing it in the absence of knowing what evidence have you actually got against you that you're facing. Your criminal lawyer hasn't vetted this, hasn't answered it. And answers that seemed great in family court have actually sunk to in criminal court, or vice versa. And the same thing happens with child custody and access. When a Children's Aid Society, for example, gets involved and wants to talk to you about an incident that's alleged about the children, I can tell you all I want, that you've got a right to silence and that anything you say can and will be used against you, and that Children's Aid is going to make notes of that. They're going to work in cooperation with police, and next thing you know, it's going to show up in criminal court. It's great for me to tell you that, but the reality is if you don't answer those questions, there's going to be ramifications, and those ramifications may be very severe for your ability to access and have custody with the kids. So there is a balancing, there is giving up and taking advantage of, and you've got to have professionals on both sides. I urge people not to try to have one lawyer accomplish all of these things, because inevitably the jack of all trades is master of none.
Well, the other thing that I found interesting, years ago, I had a case where I was able to obtain the Crown disclosure that was given to the criminal lawyer and use it in the family court proceeding. And it was a wonderful example, because in the family court proceeding, the wife said the husband owned firearms. The husband had repeatedly abused her and gave all sorts of horrific stories. And in the Crown disclosure, she said he didn't own a gun. He wasn't scary. He hit her on one occasion. And I'm not trying to minimize that, but the stories were so glaringly difficult that when I brought my motion for parenting time, the judge was completely and utterly unimpressed with the wife and found her to be completely unbelievable. So,
though, because we have rules now in particular, and I see more and more of these cases coming up in the criminal court proceedings that tell us, hey, that disclosure that we get as part of our criminal package can be used only for the purposes of defending against the criminal case. So inevitably, I get asked by the family lawyer, just make me a photocopy, or my client wants to hang on to it. I have to advise them what they can and can't use it for. However, as you know, Andrew, you can bring an application in family court that says, we've got some idea that there's this criminal case out there. We've got some idea that there's a statement out there that may be contradictory. Let's get a family court order. Then it's all kosher. It's all legitimate. We make the copies and it's free game. So you're right. It can be very, very valuable.
So those are things as family law lawyers and criminal lawyers have to work together to ensure the best possible representation. And really part of what you're trying to do is make sure that a mistake isn't made because the right hand doesn't know what the left hand is doing. And that's where the problem can happen. Now, one of the things I wanted to take you through, because this is a situation that does happen. Picture the person who is in the home. The police come to the house and they arrest the person. Now, from your perspective, what happens then? Because I can't imagine how scary that has to be, because a lot of the people who are charged with domestic violence have not had any other real meaningful interaction with the police. So this is their first time in their life. So what happens at that point?
Completely terrifying. And I mean, what happens may be a little bit different depending on which police officer happens to show up at your door. But generally speaking, I wish this were different, but generally speaking, the police aren't going to ask you, the suspect here, the accused. They're probably not going to ask you a whole heck of a lot. They're going to go to your spouse or whoever it is who's made the call to the police, the neighbor, the child, the spouse, and they're going to ask them what happened. And as soon as they get an inkling of what's called reasonable suspicion, so you become arrestable. So if somebody says, he hit me, she slapped me, he punched me, then almost anything that you say at that point is pointless. And my advice, if you actually have the good sense to get on the phone to me at that very moment, would be now is not the time to say anything. And that is incredibly difficult. It's easy advice for me to give, but incredibly difficult emotionally and intellectually for somebody to actually internalize and say, all right, I'm going to keep my mouth shut. But it really is the right thing to do. If you don't know a criminal lawyer, and most people don't, you've never been in trouble before, why would you have one? Then obviously the next call is, let me speak to my family lawyer. And the police should give you an opportunity to do that. And that family lawyer, if they know what they're doing, will know at the very least to say, don't say anything right now. I'm going to get you on the horn with a criminal lawyer. And they make the call to myself or somebody in the office, and we intervene right away as fast as we can to start having that back and forth and that communication.
And if let's say the person now is arrested, what happens then?
So it depends now on the circumstances in terms of how serious the officers on the scene think the matter is. In some cases, they'll release you right away, but they will always, even if they release you on the spot, you'll get taken back to the police station. Maybe you're questioned, maybe you're not. Maybe within an hour or 2 or 3 hours, they're going to ask you to sign what's called an undertaking. So a Form 10 and Form 11.1, you may hear those terms through the fog and the haze of what's going on around you. And so they'll say, you've got to come back to court 6 weeks from now. Sure, no problem. Then they'll slide a piece of paper in front of you, and you better read that piece of paper carefully, because almost certainly it's going to say you can't go back to the family home, even if you're the sole owner of that family home. You can't have communication with your spouse directly or indirectly. And oftentimes, if the kids were present when any of this happened, or the kids are part of the allegation where there's some question of whether you abused or assaulted any of them, you're not going to be able to have any contact with the kids either. So you're really not in a great position to negotiate that document with the officer. But what you can do is, whether you sign it or not, it's going to be imposed on you. Now you've got an opportunity as the criminal lawyer. I can take that document and work from there. If the police don't believe that it's safe to release you on the spot, then it's going to get even worse. They're going to hold you overnight. You're going to be brought for bail probably at some point the next morning. And so the most important thing is, as soon as you're in a conflict situation, even before the police ever get called, if you think you're in a high conflict divorce and this could happen, start having some idea of friends, family, coworkers. Who is it that I can call in a pinch who's going to show up in court and be what's called a surety? Someone who's going to step forward and say, you know what, I'll take responsibility for this man or woman. In the meantime, they can live with me for a short period of time. I'll sign a bail for them. and we can at least get the immediacy of the emergency under control.
Well, one of the things I typically will say to criminal lawyers that I want for flexibility, because I see these orders after they come to me, and some of them may preclude the ability to have a settlement meeting, as an example, or to attend at a mediation with lawyers when they're in separate rooms because they would be in violation of the distance requirement of how far apart they need to be. So I always try to say to the criminal lawyers, can you include, even if there are restrictions, save and accept as negotiated through counsel or as ordered by a family court? It gives a lot more flexibility. And one of the things the person who is the victim doesn't necessarily appreciate that they're creating is when they get that distance that their former spouse can't come to the home, at some point that former spouse is going to start seeing the children again, and it may be within days or weeks. And now they may be called upon to do the vast majority of the driving to allow for the parenting time because the other person can't come to the house.
Yeah, you're absolutely right. And it's a bit sloppy by criminal lawyers if you haven't made sure that the document reads that way. So, we have a policy. We can't obviously control it when police officers fill out their own document and a client hasn't called us for the promise to appear and the undertaking. But certainly when we get into court and there's going to be a release, we're always adamant that the justice of the peace, ultimately, or the Crown Attorney will usually consent to this, make sure that all of these various restrictions and conditions that are imposed always have an exception that says save for the purposes of family court proceedings or when in the company or presence of family counsel. We'll insert a variety of different phraseology like that to make sure that we know family court is going on in parallel with this. Do not tie the hands of the family court judge or even of the family lawyers. I prefer to try to keep it away from the judges too, if I can, because the expense, obviously, of having these motions in family court is extraordinary. So I'll typically try to say, or an agreement arranged by the parties in consultation with counsel. That way, you as my client's lawyer and someone else as the spouse's lawyer are able to come to a head. They sign an agreement, and that agreement is now integrated into the existing criminal order. So yes, you can come back to the house for this purpose. Yes, you can have custody and access on Wednesdays and alternate weekends, whatever it is that you guys have arranged on consent, and make this as minimally intrusive as possible when it's always going to be a major intrusion into people's lives.
And one of the problems too is it does give somebody the practical advantage of being in the home. If there's kids, they become the de facto primary caregiver. And when you're acting for the accused as a family law lawyer, you need to deal with that right away because you need to get their parenting time flowing. And you may have to bring an urgent motion, which can be an uphill battle depending on what the nature of the allegations are. Because at the end of the day, a family court judge has to feel comfortable with the parenting schedule you're creating. And sometimes it's just plain mechanics. If you're forced out of your home on a Monday, you may not have a home where your kids can even be staying with you overnight on Tuesday or Wednesday or Thursday, because it takes time. And financially, it's probably going to be the most draining time of your life because now you have two lawyers on retainer.
Front end work. So in these domestic violence scenarios, what I tend to find is kind of the arc, the ebb and flow of these cases is that early on, I get the call and then there's a tremendous amount of stuff that has to be done basically right away. And so it's very intimidating. You've got already your family lawyer who you're in the hole to for whatever it is. And now you've got a criminal lawyer who's saying, I've got a lot of work that I've got to do, not tomorrow, but right now in order to get this sorted out. And the next 48, 72 hours or even a week are going to be costly and time consuming. But if you don't do that, you could find yourself spending 2, 3, 4 weeks before that first day in court, for example, where nothing happens. And if nothing happens, as you know, Andrew, on the family court side, that means you're not staying on even keel. You're dropping in terms of your leverage, in terms of your capacity to access your children, in terms of the default position for you in the home. So once we sort out those things within hopefully a matter of days or weeks, things can settle down quite a bit. And then a number of months can go by where the family proceedings can kind of inch along. And the people who are willing to and able to take their time and not sort of fold very quickly and take the first offer that the Crown makes, because there's a lot of extortionist offers that come out of these things, they tend to get the better result at the end of the day. It's harder, but you've got to have the fortitude and the willingness to do that if you want to end up in the best scenario for the rest of your life, as opposed to just doing the quick thing that will help you now this month.
Well, and I've had a lot of people say they did the quick thing and then they regret it, because one of the flaws then is in the family court proceeding, the person who was the victim will say that the abuser always did that abuse, and they try to get some traction in a family court that this person is dangerous and they're abusive, and they try to relate that to the parenting. And it may be a perfectly good reason to do it, but you got to be mindful of it from that side. And like you said at the beginning of our conversation, there's really a dialogue from both sides, because sometimes I have clients who are petrified to report the abuse. They're worried it's going to impact their spouse's income. They're worried about the retribution they may receive from this spouse, and they are horribly frightened and scared. And one of the things I sometimes say to those clients, well, maybe you need to speak to a criminal lawyer to understand what it's going to look like if you do make the complaint. Because I can't imagine what it's to be like. Because when you see people, when they come into your office and they've been victims of domestic violence, you can really tell when they've been beaten up, because it took so much to get them in here. They usually have other people bringing them, and they are incredibly hesitant.
Yeah, and that conversation is exactly the kind of consultation that we'll have at an early phase that can save people a lot of heartache down the line. So I'll have consultations with complainants where they say, here's what I'm thinking of doing. What does this mean for me? And we don't sugarcoat it. I mean, being a victim, even in the criminal court process, is not a comfortable procedure, but it's a procedure that in many circumstances is probably the right move for you to make. But going with your eyes open, understanding what you're getting into, so that you're prepared and you get the best result for you and your family.
Well, and I think one of the challenges they face is it's easy for people who aren't victims of abuse, and they say, well, why didn't you complain earlier? And they don't understand the dynamic of what it's like to be constantly abused, constantly beat up, and to lose your voice in that marriage, and how much it takes for that person to actually come forward and to start to find their voice. And it's, as a family law lawyer, sometimes one of the fascinating things is I see someone come in who is beaten up on day one of the case when they're coming into me, and they need their support. And then I see them, if we resolve the case a year later, year and a half later, and they're a completely different person because they found their voice again. They found who they are. And it's actually, when you see that happen to somebody, it's a very nice thing to see. Now, I do see that we just got a question that came in, and it reads, if you have an old conviction for a violent offense, can that impact the custody decision? I think the question is, maybe it depends what the violent offense is. If it's a violent offense that's against your spouse or children, yes, it can. If it was something that was done in front to your spouse in front of the children, that's going to be worse than not in front of the children. So it may impact it. We also had some email questions that came in. The first one is, if I get into trial with a signed agreement on joint custody with me as a primary decision maker, would that lessen my chances of getting a temporary restraining order becoming a permanent order? And I should say there are two types of restraining order. There's a family court restraining order and there's a criminal court restraining order. In a family court restraining order, they don't allow them typically to go on indefinitely. They usually want a time period for the restraining order to lapse. Would that be the same in a criminal court?
I don't use the term restraining order per se in criminal court, but there's a variety of ways where you can have orders against you that will effectively do the same thing. So, for example, as soon as you're charged, whether you're released on a surety bail, what's called a recognizance, or whether you're released right at your own home on an undertaking, both the undertaking and the recognizance have conditions, and they do restrain your conduct. So those conditions will last either until they're varied or until the case is done. If you're found guilty, now there's likely to be a probation order of some sort, and that probation order will similarly have restraining orders attached to it. You'll also hear the terms a peace bond. So people will enter into peace bonds, both common law and under the criminal code. They're a great way to resolve many, many criminal charges. We do them all the time, but people have to understand they're not 100% perfect. There are downsides to peace bonds, and a peace bond will carry some conditions. So you have to make sure that you can abide by those, including what's likely to be a restraining order.
Okay, now another question that came in was, I've lived 2 years with kids in the matrimonial home, all the time attempting to settle with my ex a separation agreement. I paid all the bills, maintenance, kids' activities, and he would not sign and force the sale of the home. He also wants 2 years occupation rent from me while I'm not working. Will he win this lawsuit? I'm going to start with, no lawyer is going to promise you that you can win a lawsuit or lose a lawsuit. I understand why the home was sold. There may be a retroactive component of support. You may be claiming occupation rent. I know at a conference recently, one judge told a lawyer, we hear claims for occupation rent, but I can't remember the last time I saw one that was actually successful. So I'm not going to say that your case won't be the one odd one, but it's pretty rare that someone is successful with occupation rent. those were some of the questions we had. I had another question, because we talked before about what it's like to be an accused, because I think most of your work is with accused rather than the victim. But let's take the scenario that I send you a client who is a victim of domestic violence, and they're thinking of reporting to the police. What would your conversation with them look like?
So the first thing I do is just sit down with them and act as a sounding board. I want to know, what is it that happened to you? Let's discuss the background. Let's discuss the scenario. How often is this going on? Make sure that there's a safety plan there. I mean, I'm not a police officer. I'm not a social worker. I'm there as a lawyer, but obviously as a human being, I've got to make sure that this is a victim who can articulate what they need and make sure that they and their children are safe. So once we sort that out, I can have a discussion with them and say, all right, now that I know what your concerns are and what's been done to you, I can tell you what would happen if you went to police. So here are your options. You can go to the police and report this. Here's the steps that police are going to take. It is likely going to mean that your spouse is going to get arrested and charged. It is likely going to mean that they're not going to have any contact or communication with you, and possibly none with the kids. If they're the primary breadwinner, you've got to be concerned, or at least understand what that means in terms of their work environment. I'm not saying that's a reason not to lay the charges, but understand the ramifications and the implications, and understand that you're going to ultimately get cross-examined by someone just like me later on in the process if this case goes through to trial. So let's make sure that you know you've got your story straight, you've got your corroboration straight, you know what path you're going down, and you go down that path with confidence. That makes you a better witness, and it means that you're more likely to succeed at the end of the day.
Well, I think that's good advice. Now, the hardest problem I have with clients when I tell them, and they tell me they're victims of domestic violence, they're not sure whether they want to contact the police or not, and I tell them to call a criminal lawyer like you. The typical answer I get is, Andrew, I'm spending a ton of money on you. I just don't have the resources. In a perfect world, I would. And I assume there's no other resources out there other than criminal lawyers to try and give victims of domestic violence some assistance, other than some of the women's shelters that are there. But some women have a very challenging viewpoint that they don't want to speak to the women's shelters. They're nervous about that.
Once you're in the court process, so if you've laid a charge, then there is what's called the Victim Witness Assistance Program that operates out of every courthouse. I can't say I'm a huge fan of it. They do provide some level of support, but they are very much tied to the Crown Attorney's Office. So if what you want to accomplish is the same as what the VWAP, the Victim Witness Assistance Program, wants to accomplish, then great, you'll get some feedback and some assistance. But if you deviate from precisely the line that they expect you to toe, you're going to find that they're not particularly helpful. Now, there is a pilot project in place for legal aid to fund some people in circumstances where they are not particularly wealthy, in order to get that initial consultation with a panel of lawyers. But if you're already paying significant funds to a family lawyer out of your own pocket, you're almost certainly not eligible for that legal aid funding. So yes, there is a cost there. What I do tell people, though, is that the criminal side, perhaps surprisingly to many, is probably not nearly as expensive as the family side. I mean, we are kind of like the emergency surgeon. We get in, do a procedure, and get out. The GP is your family lawyer, who's going to be there each and every day for regular appointments every month and trying to get things sorted out. So, look at this as sort of getting the specialist, as it were, to come in and fix something. And if it's just a question of getting some preliminary advice, I can't speak for other lawyers, but when you're coming to our office, you may be spending a few $100s for an initial consult. If you need a letter and something to follow up, it might be $1,000 or $2,000. You don't necessarily have to drop $10,000 or $15,000 or $20,000 in order to accomplish what you want to accomplish in criminal court. Now, if you're accused and you're criminally charged, unfortunately, those numbers escalate very quickly from there.
Well, I understand it seems logical there'd be a big difference between the two. The last thing I know, some clients of mine who have been victims of domestic violence have said to me they're disappointed you commented on the Victim Assistance Program, because they say they know their spouse was going to court on a certain day and they haven't heard what happened, obviously not a trial date. And they're nervous because they're worried, is my spouse going to be able to come into the home that day? They feel very, very nervous. Is that something you see a lot of?
Unfortunately, I do, and that's just a breakdown in the system. That is not supposed to happen. I mean, the primary purpose of the Victim Witness Assistance Program is to act as that liaison between the Crown Attorney and the police and the victim, and to say, hey, here's the bail that he was released on. So now you know exactly what conditions are there. Here's what happened at this court appearance, and here's what will happen at the next court appearance. And they are supposed to keep you informed and empowered and understanding. And unfortunately, it does fail in many circumstances, so much so that I get hired by victims with means. I mean, it's only somebody who can afford to do that, to be that liaison, to do what the Victim Witness Program probably should be doing, but to stay on top of the Crown Attorney and say, what happens now? What happens next? What are you doing? My client wants you to understand what his or her goals are here, what his or her position is here. Let's be a part of this collaborative process. What you do need to understand is that it's not your call. This is a very, very common mistake. Victims don't decide whether a case does or does not proceed to trial. Even the police officer doesn't decide that once the charge is laid. That's in the hands of the Crown Attorney. So what I can do is advocate for you to the Crown for whatever that position may be. Sometimes it's to drop the charges. Other times it's to pursue charges that the Crown might be considering dropping. But it's not like flicking a switch. It's not binary.
Well, Ed, I wanted to thank you very much for having you on the show today. It went by very fast, so it was a pleasure having you. For anyone interested in learning more about Ed and his practice in criminal law, you can visit his website at crimlawcanada.com, CRIM lawcanada.com. The next Ask Andrew show is on September 20th, 2018 at 1 o'clock. If you have any questions or show ideas, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.